Good morning, good afternoon, good evening, depending on what part of the world you're joining us from. I would like to thank the organizers of this conference, the Association of Gynecological Endoscopy Surgeons of Nigeria, for inviting me to speak at the fifth international conference. I am Professor Rotimi Jaiyesimi, Group Associate Medical Director for Patient Safety, as well as a consultant in obstetrics and gynecology at the Mid and South Essex University Hospital in the United Kingdom. In addition, I'm a UK National Health Service for Patient Safety Specialist and a visiting professor at the Faculty of Law in the University of Ibadan, Nigeria. I am an expert medical witness. I have no conflicts of interest, and all I say today are my own personal views and not those of my employers. The outline of my talk, medical negligence and medical malpractice, a call for caution, includes looking at the definition of medical negligence and malpractice, gynecology endoscopy and its associated complications, the medical legal process, proving negligence or malpractice, and a call for caution for practitioners. And we will come to a conclusion. Malpractice is the improper, unskilled, or negligent treatment of a patient by a physician or any other healthcare professional. Medical negligence is the predominant theory of liability concerning allegations of medical malpractice, making this type of litigation part of tort law. Medical practice lawyers undertake or investigate the claims, whereas medical experts provide reports based on their expertise. Their reports is to help the court understand the management of the patient, what went right or what went wrong. In gynecology endoscopy, the two main procedures are laparoscopy and hysteroscopy. And just like any surgical procedure, there are inherent risks involved. These procedures are invasive and they are blind procedures. And the risks include infection, bleeding, injury to organs such as blood vessels, bowel, ureter, or uterine perforation. Other risks include thermal injury to these organs, anesthetic complications, and rarely death. It is important that you use patient information leaflets in the language the patient understands, so that they have a clear understanding of the procedure and the associated risks. Now, the process is called tort law. Injury or damages during surgery is considered to be personal injury. The patient believes that they have been wronged and they seek redress in the law courts. And the law dealing with such wrongs is known as tort law, tort being a French word. In Nigeria, the main body that regulates doctors and dentists is the Medical and Dental Council of Nigeria, and they use the code of ethics of the medical profession to judge the standard of care that practitioners provide. And the cases are heard by the Medical and Dental Practitioners Disciplinary Tribunal. The process is not a criminal proceeding, it's more of a civil proceeding, and the standard of proof is based on the balance of probabilities. That is, more likely than not, it happened or it did not happen. It is for the claimant to prove the case. The defendants don't have to prove that they did anything right or wrong. The claimant, if not satisfied with uh, an outcome that doesn't favor them, can appeal to the Court of Appeal or to the Supreme Court of Nigeria, that is the highest court in the land. Now, claimants and defendants, through their solicitors, instruct medical experts. The role of medical experts is to help the court understand the issues involved in the management of the patient, and these are based on material facts as well as the scientific knowledge and literature. Medical experts are independent, and though the services are obtained through solicitors, it does not mean that the report must favor the instructing party. The role of the Consumer Council in Nigeria remains uncertain. I'm sure you will remember that in the last few months, we've had a high-profile case that the Consumer Council in Nigeria listened to, but their role still remains unclear in medical legal cases. Now, to prove medical negligence, that is the tort of negligence, claimants have three hurdles or three elements in the tort of negligence that they must overcome. The first is to establish that there was a duty of care. This is not too difficult because as soon as a patient sees a practitioner, it's a sum of quasi-contract, and that is a duty of care. The practitioner has a duty to take care of the patient. The second is the standard of care and the breach of the standard of care. This was established by Boland versus Friend in 1957, where Justice McNair said it is what a reasonable and responsible group of healthcare workers with similar skills to the defendant would or would not have done. And the standard of care can be achieved by practitioners by being professional in what we do, communicating and explaining effectively, discussing all alternative forms of treatment or investigations, using patient information leaflets to aid this process. It is also important that practitioners document their history, physical findings, and the management plan comprehensively and contemporaneously. Now, there has been a relatively new ruling, 2015, that's about 6 years ago, in Scotland, where a doctor, Nadine Montgomery, who had diabetes in pregnancy, of short stature, inquired about the size of the baby, but her obstetrician did not discuss the risk of shoulder dystocia with her. Unfortunately, the baby had shoulder dystocia and subsequently developed cerebral palsy due to hypoxic insult. Montgomery sued for negligence, and the Supreme Court found in her favor in 2015. Now, that has led to what was said to be a moment in medical legal practice, or even in professional practice, where it is said that rather than being a matter for clinical judgment to be assessed by doctors, a patient should be told whatever they want to know, not what the doctor thinks they should be told. I cannot but stress that again. A patient should be told whatever they want to know, not what the doctor thinks they should be told. And the other hurdles are establishing that there was a breach of the duty of care, and the medical report is what is used the court listens to the medical report from the claimant's medical expert, as well as the defendants, and the court puts weight on what they believe to be the most appropriate version of events. And where a breach of the duty of care is established, it is also looked at the causation that is but for this breach of duty of care. This injury would or would not have happened. And so it is for the courts to establish causation. And if this is proven, then the court also determine liability as well as the compensatory financial cost that will be awarded to the claimant. Now, as gynecologists or endoscopists, one must be mindful of the ways to avoid pitfalls. Professionalism in our practice is paramount. Obtaining consent is essential. That is, patient knows what they are signed for. And documentation is also important in that what is not written is not done. And the reasons to be cautious is that we're having more medical errors occurring globally, not just in Nigeria, and medical legal claims are on the increase. This is fueled by enlightened populace as well as the availability of social media. And more lawyers are taking interest in this particular area of law practice. For gynecology endoscopists, it is important that because these cases are undertaken at one-stop clinics or even as day case surgery, my advice would be that the endoscopist should be the one taking the consent, giving time to the patients to reflect on what is on offer, as well as the risk before the procedure is carried out. It is important that a meaningful discussion and mutual understanding takes place by all parties involved. This enhances patient understanding and protects the doctor from liability in medical negligence cases. A survey of why patients sue in Nigeria showed that it was lack of good communication, insensitive handling of adverse clinical events, and the arrogance of healthcare professionals. In a case in 2005, Dr. Onaiwo was sanctioned because he or she gave no apology when the daughter of a diseased patient wanted to know exactly what happened. Now, I don't wish going through a medical legal process on any doctor because it is fraught with a lot of problems. Psychological stress during and after the case, and if the claimant wins, then there's reputational damage to the individual or the organization. And this could lead in loss of patronage and financial income. And that's not to also talk about the legal cost involved, the amount of money you have to pay to your legal team. It is for this reason that it's important that we as healthcare professionals protect ourselves. And this can be achieved by equipping ourselves with knowledge, making sure our skills are up to date and our performance are excellent. This can be attained by continuous professional development, including simulation exercises. And we should work within our area of expertise. Documentation appears again, and I cannot overemphasize the need for good record keeping. It could be what saves you in a law court. Because of the potential huge amount of money that a successful claim could incur, I would advise that practitioners should consider taking liability insurance so that in the event of a successful claim, it will be the insurance company paying out another doctor. It's important that we as doctors are open and transparent when things go wrong. This may prevent the defendant or potential defendant from going down the path of medical legal process. In conclusion, no practitioner sets out to cause harm to patients, but these things do happen because we are human. As we say, to err is human. However, a practitioner must practice to an acceptable standard to avoid facing malpractice and negligence claims. Patient safety should be at the center of everything we do when patients come under our care. Caution is required while we have a duty of care. There are no winners in medical negligence. The patient has suffered injury. The doctor or healthcare professional may suffer a lot of reputational damage, a lot of anxiety and stress. And it is for this reason that my take-home message will be that we as medical practitioners should ensure that our delivery of services is excellent and that patients do not come to harm. Thank you for listening, and I will be willing to take questions. Thank you.